Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute legal advice, professional counseling, or a substitute for the services of a licensed attorney or mediator. Laws regarding domestic relations, divorce, and alternative dispute resolution vary significantly by state and country, and they are subject to frequent changes. Viewers should conduct their own due diligence and consult with qualified legal professionals in their specific jurisdiction before making any decisions regarding their personal or legal affairs. Imagine standing in a courtroom in 1970. In the United States, if you wanted to end your marriage, you often had to prove a moral failure. You had to provide evidence of adultery, extreme cruelty, or willful desertion. It was a blood sport, a public airing of private trauma designed to find a winner and a loser. But while American couples were locked in these high-stakes adversarial battles, a quiet revolution was simmering across the Atlantic and in small pockets of the American Academy. Today, we see a world where divorce mediation is a multi-billion-dollar industry, but the path to get here was paved with radically different philosophies. In the U.S., mediation became a tool for efficiency and clearing backlogged court dockets. In Europe, it was often birthed from a social democratic desire to preserve the psychological well-being of the next generation. Why is it that in some European nations, mediation is a mandatory hurdle before you can even see a judge, while in the U.S., it remains a fragmented state-by-state patchwork of private contracts and court-ordered sessions? The answer lies in a hidden history of legal theory, cultural shifts, and the fundamental way these two societies view the contract of marriage. For the modern viewer, understanding this historical divide isn't just an academic exercise. If you are navigating the complexities of modern separation, or if you are interested in how social systems evolve to handle human conflict, this deep dive provides the essential context. We are going to solve the mystery of why the American system feels so much more litigious and expensive compared to the structured, often state-subsidized frameworks of the EU. By the end of this masterclass, you will understand the potential outcomes of these two differing paths, and how the history of mediation informs the current legal trends that dictate how families dissolve today. To understand the present, we must look at the 1960s and 70s as the great fault line of family law. Before this era, the fault-based system reigned supreme. This created a massive problem: perjury. Couples who both wanted to leave a marriage would literally fabricate stories of mental cruelty just to satisfy the legal requirements of the time. This undermined the integrity of the court. In the United States, the turning point was 1969, when California Governor Ronald Reagan signed the Family Law Act, introducing the first true no-fault divorce law in the nation. This changed everything. Suddenly, the why of the divorce didn't matter to the judge, only the how of the division. However, this created a new crisis. Without the fault framework, the courts were flooded. Judges who were used to deciding who the bad guy was were now expected to be accountants and child psychologists, dividing assets and determining custody schedules for thousands of families. The system was breaking. This is where mediation entered the American consciousness, not necessarily as a preferred moral choice, but as a pressure valve. Early pioneers like O.J. Kugler, a Georgia attorney who founded the Family Mediation Association in 1975, began looking at labor management dispute resolution as a blueprint. They asked a radical question: if we can mediate a strike between a union and a corporation, why can't we mediate the end of a household? Across the ocean, the European trajectory was taking a different shape, influenced by the rise of the welfare state. In countries like the United Kingdom and France, the focus wasn't just on court efficiency. It was on the best interests of the child. This phrase, which we take for granted now, was a revolutionary legal standard. European social theorists argued that the adversarial nature of the British common law, or the French civil code, was inherently traumatizing to children. They didn't want a pressure valve for the courts. They wanted a buffer for the family unit. Let's look at the data from that era to see the scale of this shift. In the mid-1970s, divorce rates in the U.S. were skyrocketing, peaking at about 5.3 per 1,000 people by 1979. The legal fees associated with these divorces were draining the middle class of their primary asset, home equity. Case studies from the early 1980s show that a contested divorce in a major U.S. city like New York or Los Angeles could easily cost upwards of $20,000 in 1980 dollars, roughly $75,000 today when adjusted for inflation. Mediation was marketed as the blue ocean strategy for the American middle class, a way to bypass the lawyer-up culture that was consuming family wealth. Meanwhile, in Europe, the historical trend was moving toward institutionalization. In Scandinavia, specifically Sweden and Norway, the state began integrating social workers into the divorce process much earlier than in the US. By the time the 1980s arrived, many European jurisdictions were experimenting with comprehensive mediation, which didn't just look at the money, but at the long-term communication patterns of the parents. While an American mediator might have been a retired judge looking at a spreadsheet, a European mediator was often a trained psychologist looking at a family tree. This brings us to a critical distinction in the historical evolution of these two regions: the private versus public divide. In the US, mediation evolved primarily as a private market service. This led to a Wild West period in the 1980s and 90s where there was very little regulation on who could call themselves a mediator. You could be a priest, a therapist, a lawyer, or a retired business executive. This lack of standardization created a massive variance in quality. In contrast, many European nations moved toward a national accreditation model. For example, the UK established the Family Mediation Council to ensure that every mediator followed a strict, state-approved protocol. Why does this matter to you today? Because the historical DNA of these systems dictates your experience. In the US, because mediation grew out of a desire for efficiency, it is often evaluative. This means the mediator might tell you, based on my experience, a judge is going to give your spouse 50% of this pension, so you might as well agree to it now. It is a shadow of the courthouse. In much of Europe, the history of mediation is transformative or facilitative. The goal isn't just to reach a settlement. It is to transform the way the two parties interact so they can co-parent for the next 20 years. Consider the case study of mandatory mediation. In the US, this is a controversial topic that varies by county. In some parts of Florida or California, you are required to see a mediator for custody issues before you can see a judge. Historically, this was met with fierce resistance from the American Bar Association, who feared it would deprive citizens of their day in court. However, in the UK, the Mediation Information and Assessment Meeting, or MIAM, became a legal requirement for most family court applications. The European historical trend favored the collective social good, reducing conflict for the sake of the community, while the American historical trend struggled to balance individual due process with the need for a faster, cheaper alternative to the trial. We also have to look at the economic drivers. In the United States, the divorce industry is a significant part of the legal economy. There was a historical and some argue ongoing financial incentive for the process to remain adversarial, as litigation generates more billable hours than mediation. In Europe, where legal aid is more common and the state often foots the bill for low-income families, the government had a direct financial incentive to make mediation the primary path. Every case settled in mediation saved the European taxpayer thousands of euros in court costs and social services. This led to a historical push for publicly funded mediation in countries like the Netherlands, which created a systemic filter that redirected families away from the mahogany benches of the courtroom and toward the round tables of the mediation suite. As we move through this 10-part series, we will break down the specific legal milestones, from the 1980 Uniform Mediation Act in the US to the 2008 EU Cross-Border Mediation Directive. We will examine how these two paths created two very different worlds for the millions of people who go through them every year. Whether you are looking at this through the lens of a legal professional, a student of history, or someone standing at the threshold of a major life change, understanding these historical foundations is the only way to navigate the complexities of the modern system. We are peeling back the layers of a system that was built over 50 years of trial, error, and radical social change. To understand why your cousin in Chicago and your colleague in Munich might have two completely different experiences ending a marriage in 2026, we have to look at the divergence of the 1980s. This was the decade where the United States and Europe stopped sharing a roadmap for domestic conflict. In the US, the 1980s were defined by the emergence of the private practitioner model. Imagine a character named Alex, a high-earning software consultant in Austin, Texas. In 1985, if Alex wanted to avoid a public courtroom brawl, he would have searched for a private mediator who was likely a pioneer operating without a state-sanctioned license. This is the era of the solo practitioner. These early American mediators were often renegade attorneys who were tired of the win-loss outcomes of litigation, or social workers who believed they could handle the emotional math better than a judge. The historical trend in the US during this period was the commodification of peace. Because the American government did not provide a centralized mediation infrastructure, the market stepped in. This created a high barrier to entry system where only those who could afford to pay several $100s an hour for a private neutral could access the benefits of a collaborative divorce. Case studies from this era show a stark divide. Wealthy couples in metropolitan hubs like New York and San Francisco were utilizing private mediation to keep their asset divisions out of the public record, while lower-income families remained trapped in the traditional, overcrowded court system. Contrast this with the historical development in Western Europe, particularly in France and Germany. In 1984, the French government began experimenting with mediation familiale, not as a luxury service, but as a public utility. They integrated mediation directly into the Tribunaux de Grande Instance. While Alex in Texas was paying a private consultant out of pocket, a couple in Lyon might have been referred to a state-subsidized mediator, whose role was woven into the social safety net. This is the public utility model versus the private market model. One of the most significant data points from the 1980s is the emergence of the model standards of practice for family and divorce mediation in the U.S. This was a desperate attempt by professional organizations to bring order to the chaos. At the time, there was no uniform training. Some mediators believed in evaluative mediation, where they would look at Alex's assets and tell him exactly what a judge would do, effectively acting as a pseudo-judge. Others practiced facilitative mediation, where they refused to give any legal opinion, focusing entirely on the communication between the parties. This inconsistency remains a hallmark of the American experience today. In Europe, the trend was moving toward a holistic civil law approach. In Germany, the concept of Trennung und die Scheidung, separation and divorce, became heavily influenced by the Cocchimer model in the early 1990s. This was a revolutionary interdisciplinary approach where judges, lawyers, and mediators worked together as a network of professionals to de-escalate conflict. Imagine if Alex's lawyer in Austin was legally required to cooperate with the opposing lawyer to lower the temperature of the room. In the U.S., that would often be seen as a violation of zealous advocacy, a core tenet of the American adversarial system. In the German model, the zealous advocacy was shifted away from the parent's ego and toward the child's stability. Let's look at the financial step-by-step details that shape these systems. In the U.S., the 1988 Family Support Act placed a heavy emphasis on child support enforcement and privatization. This meant that mediation sessions often became hyper-focused on the bottom line. The sessions were structured as business negotiations. Step 1, identify all community property. Step 2, run the state-mandated child support calculator. Step 3, negotiate the offset of assets. It was, and often still is, a cold transactional process. In many European jurisdictions, the historical trend focused on the social-psychological step-by-step. A mediation session in Norway or Denmark during the same period would start not with a spreadsheet, but with a parenting plan discussion that was mandatory before any financial discussions could even begin. The data shows that by the late 90s, countries with this children-first mediation sequence saw a 15 to 20% higher rate of long-term compliance with custody agreements compared to the U.S. money-first sequence. Imagine if the U.S. had followed the European path. If Alex in Austin had been required to attend a state-funded information session, where the psychological impacts of litigation were explained before he could even file a petition for divorce, the entire landscape of the American legal economy might have shifted. Instead, the U.S. developed a litigation-adjacent mediation culture. This is where mediation happens at the 11th hour, usually on the courthouse steps, under the intense pressure of an impending trial date. This pressure cooker mediation is a uniquely American phenomenon. In Europe, the historical trend has been early intervention. By intervening months before a court date, European mediators aim to prevent the hardening of positions. In the U.S., because mediation is often seen as a way to settle a case that is already in progress, the parties have often already spent $10,000 on discovery and motions, making them more bitter and less likely to compromise. The differences extend even to the physical space. American mediation historically takes place in law firm conference rooms, glass tables, mahogany walls, and the looming presence of legal binders. European mediation frequently occurs in family centers or neutral municipal buildings, designed to feel less like a battlefield and more like a counseling office. This environmental psychology plays a massive role in potential outcomes. Case studies suggest that physical environments that mimic a neutral home, rather than a corporate office, lead to more durable agreements and fewer post-divorce return trips to court. As we analyze the historical trends of the 1990s, we see the U.S. grappling with the unauthorized practice of law, UPL. Lawyers were terrified that non-lawyer mediators were stealing their business and giving bad legal advice. This led to a series of restrictive regulations in various states that effectively attorneyized mediation. In many U.S. states, you will still find that mediation is only truly effective if each party also brings their own lawyer to the session. This is known as attorney-represented mediation. It doubles or triples the cost. Meanwhile, Europe was moving toward the single mediator model, where the mediator is the only professional in the room. This was supported by a legal framework that treated the mediator as a guardian of the process, not a legal advisor. The outcome? A streamlined, significantly cheaper process that prioritized the verbal agreement of the parties over the legal jargon of the representatives. Why did the US become so obsessed with lawyer-led mediation while Europe embraced mediator-led sessions? The answer lies in the fundamental distrust of the state versus the fundamental distrust of the individual. In the US, we trust our individual rights and our day in court, which requires a legal gladiator. In Europe, there is a historical trust in the administrative state to provide a fair, standardized process for all citizens. But there is a dark side to both. In the US, the private market means that if you can't afford a top-tier mediator, you might end up with a court-appointed official who has only 20 minutes to shuttle between rooms and force a deal. In Europe, the mandatory nature of some systems can feel like a bureaucratic hurdle that ignores the nuances of domestic abuse or power imbalances. As we look toward the year 2026, these two histories are colliding in the digital space. Online dispute resolution, ODR, is the new frontier. But will ODR follow the American model of high-speed, transactional settlement, or the European model of slow, transformative communication? And what happens when a US citizen divorces an EU citizen? Which historical legal ghost wins the battle for the jurisdiction? In the next part, we are going to dive into the specific laws that changed the game, including the 2001 Uniform Mediation Act in the US, and why it failed to create the united front its creators promised. We will also look at the Scandinavian secret, how countries like Sweden have almost entirely eliminated the concept of a contested divorce through 40 years of social engineering. What happens when the court is no longer a place for combat, but a place for filing paperwork? The answer might change everything you think you know about fighting for your rights. To understand the true weight of the Scandinavian secret, we have to look at how Sweden and Norway fundamentally deconstructed the idea of the courtroom as a battlefield. In the United States, we are conditioned to believe that a divorce is a legal war where you must fight for your rights. Imagine a character named Sarah in Seattle in 2026. If Sarah decides to end her marriage, her first instinct is likely to call a lawyer. The legal framework she enters is one of adversarial discovery, where she must seek and seize financial documents to protect herself. In contrast, imagine Sarah's counterpart, Elsa, in Stockholm. For Elsa, the process is largely administrative. Sweden's historical trend has moved toward a system where divorce is a notification to the state, not a request for permission. This brings us to the first major pillar of the Nordic model, the 1987 Swedish Marriage Code. This legislation was a masterclass in social engineering because it decoupled the dissolution of the marriage from the resolution of the conflict. In the US, we often try to do both at once in a high-pressure mediation session. In Sweden, the divorce is granted almost automatically after a 6-month reconsideration period if children are involved. This cooling-off period is not just a wait. It is a structured time where the state provides accessible, often free, family counseling and mediation. The data shows that by removing the threat of a judge's hammer during the initial emotional fallout, the potential outcomes for long-term co-parenting improve drastically. The step-by-step reality in Scandinavia is a far cry from the American experience. Step 1 in the Nordic model is the samarbete etter samlivsbrud, or cooperation after breakup sessions. These are mandatory in Norway for parents with children under 16. It is not about who gets the house. It is about how the parents will communicate. Case studies from the Norwegian Institute of Public Health indicate that these mandatory sessions reduce the need for court intervention in over 80% of cases. Compare this to the American historical trend, where mediation is often used as a last resort once the parties are already financially exhausted. In the US, the 2001 Uniform Mediation Act was supposed to be our answer to this lack of standardization. It was a massive undertaking by the National Conference of Commissioners on Uniform State Laws. The goal was to ensure that what Sarah says in mediation in Seattle is treated with the same confidentiality as it would be in Miami. However, because the U.S. prioritizes state sovereignty, only about half of the states have adopted it in its entirety. This has created a fragmented legal landscape. If Sarah moves from a UMA state to a non-UMA state, her expectation of privacy in mediation could vanish. This lack of uniformity is a primary reason why American mediation remains so lawyer-heavy. If the rules are different everywhere, you need a specialist just to navigate the mediation itself. Let's look at the Scandinavian secret regarding asset division. In the US, we have complex rules like community property versus equitable distribution. This creates an environment where mediation is often spent arguing over what constitutes a marital asset. In Sweden, the historical trend has been toward a very clear mathematical split that is rarely litigated. This allows the mediator to skip the forensic accounting and focus on the future. Imagine if Sarah didn't have to spend $5,000 on an appraiser, because the state's automated digital ledger already provided a valuation of the marital home based on recent tax assessments. This is the reality in many digitally integrated European societies in 2026. The divergence becomes even more apparent when we examine the concept of parental responsibility. In the US, we still use the term custody, which historically implies ownership or control. This linguistic choice frames mediation as a win-loss game. In Europe, the 1989 Children Act in the UK and subsequent reforms across the continent shifted the focus to responsibility. You don't get the kids, you share the responsibility. This isn't just semantics. It is a historical shift in legal theory that changes the mediator's entire approach. Instead of a custody schedule, European mediators help create a living plan. This leads to a fascinating data point: the duration of conflict. Historical trends in the US show that contested divorces can drag on for 18 to 36 months. In the Scandinavian model, the administrative path usually concludes within 6 to 12 months. This reduces what sociologists call toxic stress on the family unit. By making the process boring and administrative rather than dramatic and legalistic, the state removes the incentive to fight. However, we must address the American pushback. Many legal scholars in the US argue that the European model lacks due process. They worry that a mandatory state-run mediation system might overlook a spouse who is being financially controlled or emotionally abused. This is a valid concern. In the US, the presence of attorneys in mediation acts as a safeguard, albeit an expensive one. Case studies of power imbalance in American mediation highlight that without a lawyer present, the stronger personality often dominates the outcome. This is why the US historical trend has clung to the attorney-represented model, even as it tries to adopt mediation. In 2026, we are seeing a new phenomenon: the hybrid model emerging in countries like the Netherlands. The Dutch divorce without a judge movement is a fascinating middle ground. It allows couples to finalize their divorce through a certified mediator notary, bypassing the court entirely, provided they meet certain criteria. This is a step-by-step evolution that the US is watching closely. Step 1. Both parties agree to a neutral mediator. Step 2. They create a comprehensive settlement agreement, covering all bases. Step 3. A specialized notary reviews the document for legal fairness. Step 4. It is registered with the state. No judge, no courtroom, no day in court. Imagine Sarah in Seattle having access to a notary divorce. She could save tens of thousands of dollars. But the US historical trend of litigation as a right makes this difficult to implement. There is a deep-seated American belief that a judge must bless the end of a contract for it to be valid. This legal paternalism is something Europe has largely moved past. But what happens when the administrative state gets it wrong? In the next part, we will explore the dark side of the European model, instances where mandatory mediation has failed victims of domestic strife, and why some European activists are actually looking to the American adversarial system as a way to find justice. We will also analyze the cost of peace by looking at the specific billable hours of a typical 2026 American mediation versus a state-subsidized German session. You will see exactly where every dollar goes and why free mediation might sometimes be the most expensive mistake a person can make. We are moving into the mechanics of the money and the hidden costs of both systems that no one tells you about until the final invoice arrives. The mechanics of the money in the American mediation system are built on a foundation of individual responsibility and market-rate professional services. To understand the true cost, let us look at a character named Michael in Chicago in 2026. Michael is a mid-level manager at a logistics firm. When he enters mediation, he is not just paying for a mediator. He is navigating a multi-layered financial ecosystem. The historical trend in the United States has been to treat divorce as a high-stakes civil contract dispute. Consequently, the billable hour reigns supreme. Michael might find a mediator who charges $400 per hour, but the hidden cost lies in the prep work. In the American model, step 1 is the mandatory financial disclosure, a grueling process of digging through 5 years of tax returns, 401k statements and credit card bills. If Michael or his spouse misses a single bank statement, the mediation can grind to a halt, costing thousands in wasted time. This leads to the phenomenon of shadow costs. In the US, most successful mediations are attorney-assisted. This means Michael is paying $400 an hour for the mediator, plus another $350 an hour for his own lawyer to sit in the room, plus $350 for his spouse's lawyer. In a single 6-hour session, the family unit has drained $8,700 from their collective savings. This is why the U.S. historical trend shows that while mediation is cheaper than a trial, it is still a significant financial burden that often requires participants to take out personal loans or deplete their emergency funds. Now let us flip the script and look at the German system, which operates on a drastically different financial philosophy. In Germany, the cost of the legal process is often dictated by the Verfahrenswert, or the object value of the case. The state sets a table of fees based on the couple's net income and assets. If a couple in Berlin with a similar income to Michael enters the system, their costs are largely predictable and capped by statute. The historical trend in Germany and much of the European Union has been to prevent the legal system from bankrupting the family. This is achieved through a state-subsidized mediation infrastructure. If Michael were in Berlin, he might access mediation through a Jugendamt, a youth office, or a state-recognized family counseling center where the fees are either sliding scale or entirely covered by social insurance. However, the dark side of the European model emerges when we examine the concept of mandatory participation and the quality of the neutral party. In some European jurisdictions, the pressure to settle is so high that nuanced financial protections can be overlooked. Imagine a scenario where a lower-earning spouse is pressured into a quick settlement in a state-funded session. Without the protective shield of an aggressive American-style attorney, that spouse might agree to waive future pension rights or spousal support just to end the process. Case studies from the early 2010s in the United Kingdom, following the introduction of the Legal Aid, Sentencing and Punishment of Offenders Act, showed that when legal aid for divorce lawyers was cut, many vulnerable individuals felt forced into mediation without a clear understanding of their long-term financial rights. The potential outcome in these cases was a settlement that looked peaceful on paper, but led to long-term poverty for the custodial parent. In the United States, the cost of peace is often the cost of protection. Michael pays more because he is buying a guarantee of due process. In 2026, the data indicates that an average mediated divorce in a major U.S. city costs between $10,000 and $15,000, whereas a fully litigated trial could easily exceed $100,000. For Michael, the $15,000 is a strategic investment to avoid the $100,000 catastrophe. In Europe, the average cost might be closer to 2,000 or 3,000 euros, but the trade-off is often a more rigid, bureaucratic experience where individual creative solutions, like complex tiered alimony or specific stock option vesting schedules, are harder to implement because the state-subsidized mediators are trained to follow a standardized template. Let us look at the step-by-step detail of the American mediation invoice. Step 1. The retainer. Most private U.S. mediators require an upfront deposit of $2,000 to $5,000. Step 2. The administrative fee. This covers the software used for digital filing and communication. Step 3. The session fee. This is the actual time spent at the table. Step 4. The drafting fee. After an agreement is reached, the mediator or an attorney must draft the Memorandum of Understanding, or a marital settlement agreement. In the U.S., this drafting phase is where the money often disappears. A 30-page legal document that must survive the scrutiny of a judge can take 10 or more hours to perfect. Contrast this with the French model of the Convention de divorce par consentement mutual. Since 2017, France has largely removed the judge from the process for mutual consent divorces. Instead, each party has a lawyer, and they sign a private contract which is then deposited with a notary. The cost of the notary is a flat fee, often less than 100 euros. The historical trend here is the privatization of the finality, but within a strictly regulated price cap. The French system assumes that the lawyers will protect the interests of the parties, so the state doesn't need to oversee the mediation session itself. But there is a hidden financial risk in the European notary or administrative model: the lack of forensic depth. If Michael's spouse in Chicago is hiding cryptocurrency or offshore accounts, the American system has robust, albeit expensive, tools like subpoenas and depositions to uncover those assets. In a streamlined European administrative divorce, the focus is on speed and cooperation. If one party is dishonest, the simplified mediation process can become a tool for financial fraud. Case studies from the European Court of Human Rights have seen challenges where individuals claimed their right to a fair trial was effectively bypassed by a system that pushed them into a simplified mediation, where they were unable to properly audit their spouse's true net worth. This brings us to the 2026 reality of the divorce tax. In the US, the tax implications of asset transfers in divorce are a minefield. An American mediator must be hyper-aware of the Section 1041 transfers of the Internal Revenue Code. A mistake here can lead to a massive tax bill 3 years down the line. In Europe, many countries have a more integrated tax and family law system, where the state automatically recognizes the division of property as a non-taxable event. The US mediator is often forced to play the role of a tax advisor, which increases the billable hours and the complexity of the sessions. As we look at these two financial worlds, a clear picture emerges. The US system is a high-cost, high-protection model that thrives on private expertise. The European system is a low-cost, high-efficiency model that relies on state structure and standardization. But what happens when the emotional stakes are higher than the financial ones? What happens when mediation is used not just to divide a bank account, but to decide the fate of a child's education or religious upbringing? The next part of our masterclass will dive into the most sensitive area of all: the battle for the children. We will analyze the historical shift from the tender years doctrine to the modern presumption of 50-50 shared parenting. We will explore why some European nations consider the American concept of visitation to be a violation of human rights, and how the US is currently struggling with a surge in high-conflict custody cases that mediation is failing to solve. We will look at the rise of the parenting coordinator, a role that is half mediator and half police officer, and why this might be the future of family law on both sides of the Atlantic. The shift from money to souls is where the history of mediation gets truly personal and, in some cases, truly heartbreaking. The battle for the children represents the most profound shift in the history of mediation, moving from a property-based view of offspring to a rights-based view of the family unit. To grasp the current climate of 2026, we must first look at the ghost of the tender years doctrine. Historically, in both the United States and Europe, there was a legal presumption that young children belonged with their mothers. This made mediation relatively simple but inherently biased. Mediation in the 1950s and 60s wasn't about sharing time. It was about negotiating the terms of the father's limited access. Imagine a character named David in Ohio. In a historical context, David would be fighting an uphill battle just to secure every other weekend. But as mediation evolved in the 1990s, the US saw a massive push toward the best interests of the child standard. This sounds noble, but in practice, it turned mediation into a psychological evaluation. In the US, mediators began incorporating child custody evaluators into the process. Step 1 of this modern American deep dive involves the appointment of a guardian ad litem or a forensic psychologist who interviews the children and observes the parents. This data is then fed back into the mediation session. The cost of these experts can range from $5,000 to $20,000, turning the mediation table into a high-stakes clinical review. Contrast this with the historical trend in Belgium and Italy. In 2006, Belgium passed a landmark law making joint physical custody the default starting point for all negotiations. This fundamentally changed the math of mediation. In David's Ohio mediation, he has to prove why he should have 50% of the time. In a Brussels mediation, the burden of proof is flipped. The spouse wanting sole custody must prove why the 50-50 split would be harmful. This is the presumption of equality. Case studies from the European Union show that when the law starts with a 50-50 assumption, mediation sessions are significantly shorter and less aggressive. There is no prize to be won because the starting line is already at the finish line. One of the most innovative and controversial historical trends in Europe is the voice of the child. In countries like Germany and the Netherlands, children as young as 12, and sometimes younger, have a legal right to be heard during the mediation process, often through a specialized child-inclusive mediator. This is not about letting the child choose where to live, which is a common misconception. It is about allowing the child to express their lived experience to the mediator, who then carefully brings that perspective back to the parents. Imagine David in a room with his spouse, and the mediator says, "Your son mentioned that he feels like a messenger between two warring camps during the handoffs." In the European model, this direct feedback acts as a psychological circuit breaker. It forces the parents to stop looking at each other and start looking at the human cost of their conflict. In the US, child-inclusive mediation is growing but remains rare due to fears of triangulating the child or causing further trauma. American mediators often prefer to keep the children entirely insulated from the process, which some European practitioners argue creates a vacuum where parents negotiate based on their own egos, rather than the child's actual needs. This brings us to the rise of the parenting coordinator in the United States. As we sit in 2026, we are seeing a historical peak in high-conflict cases that traditional mediation cannot solve. These are cases where the parents cannot even agree on a drop-off time at a local Starbucks without a digital argument. The parenting coordinator is a quasi-judicial role born out of the failure of standard mediation. They have the power to make binding decisions on minor issues like holiday schedules or extracurricular activities. Step by step, they act as a referee. In the US, this is a private, pay-to-play service. For families like David's, this can mean a monthly retainer just to keep the peace. In Europe, the trend has been to move these high-conflict cases into the realm of mandatory social services. In Sweden, the samarbetssamtal or cooperation talks are handled by municipal social workers. If mediation fails, the state doesn't just send you to a high-priced coordinator. They wrap the family in a layer of social support and monitoring. The data suggests that this public approach leads to lower rates of parental alienation over a 10-year period, compared to the private U.S. coordinator model. Let's look at the data on shared parenting. Historical trends show that in 1990, only about 10% of U.S. divorces resulted in truly shared physical custody. By 2026, that number has climbed closer to 40% in many states. In Europe, countries like Sweden see shared parenting in over 50% of cases. The correlation is clear. The more a society uses mediation as its primary tool rather than litigation, the higher the rate of shared parenting. This is because litigation naturally drives people into corners, while mediation naturally pulls them toward the center. However, there is a dark side to the mediation of souls. Case studies in both the US and the EU have identified a risk called the friendly parent provision. This is a historical legal trend where the parent who is seen as more willing to cooperate in mediation is rewarded by the court. While this sounds good, it can be dangerous in cases of coercive control. A victim of domestic abuse might be afraid to speak up in mediation for fear of being labeled an uncooperative or high-conflict parent, which could jeopardize their custody. In response to this, the U.S. has developed specialized domestic violence screening protocols for mediators. Step 1 is a private, separate meeting with each party to check for power imbalances. Step 2 is the use of shuttle diplomacy, where the parties are never in the same room. In 2026, many European nations are following suit, but the integration varies. Spain, for instance, has specialized courts for violence against women that often bypass mediation entirely to ensure safety. The historical comparison also reveals a fascinating difference in the concept of time. American mediation is often obsessed with the schedule, the 2-2-3 split or the alternating weeks. It is a logistical puzzle. European mediation, particularly in the Mediterranean countries, often focuses more on the concept of family continuity. They are more likely to negotiate around the extended family, ensuring the child maintains a deep connection with grandparents and cousins on both sides. In David's U.S. mediation, the grandparents are rarely mentioned. In a Spanish mediation, they might be a central pillar of the agreement. As we conclude this deep dive into the children, we must ask, are we moving toward a global standard? The Hague Convention has already standardized how we handle international child abduction, but we are far from a unified theory of mediation. The potential outcomes of these two systems are diverging as technology enters the fray. What happens when an AI mediator in 2026 is tasked with creating a parenting plan? Will it prioritize the mathematical efficiency of the American model or the psychological depth of the European one? In the next part, we will explore the digital frontier. We will look at how Silicon Valley and European tech hubs are building the platforms that will replace the conference room entirely. We will examine the step-by-step reality of online dispute resolution and why your next mediator might not even be a human being. The shift from the mahogany table to the smartphone screen is the next great evolution in the history of human conflict, and the data suggests it is happening faster than anyone predicted. The digital frontier of 2026 has transformed the mediation landscape from a physical destination into a cloud-based interface. To understand how we arrived at the era of the virtual mediator, we have to look back at the late 2010s and the catalyst of 2020. Before the global shift toward remote work, mediation was almost exclusively an in-person ritual. In the United States, the historical trend relied on the presence of a neutral party in a neutral room to read body language and manage micro-expressions. Imagine a character named James in Denver. In 2018, James would have spent his Tuesday morning driving to a downtown office, paying for parking, and sitting in a lobby across from his soon-to-be ex-spouse, feeling the palpable tension in the air. This physical proximity was considered essential for the transformative power of the process. However, the rapid adoption of online dispute resolution, or ODR, began to dismantle the necessity of the conference room. What started as a way for e-commerce giants to settle small claims disputes between buyers and sellers was adapted for the high-stakes world of family law. By 2026, the potential outcomes of a digital mediation are often indistinguishable from in-person sessions, but the historical path to this acceptance was fraught with debate. Step 1 of the ODR revolution was the shift to video conferencing. In the US, this was initially met with resistance by the legal community, who argued that the digital screen filtered out the empathy required for family resolution. But the data told a different story. Case studies from early adopters in Michigan and Utah showed that when parties mediated from the comfort of their own homes, their cortisol levels were lower, and they were less likely to trigger each other's fight-or-flight responses. This leads us to the current state of asynchronous mediation. This is where the US and Europe are seeing a massive divergence in technological philosophy. In the US, the market has favored platforms that prioritize the transactional. Imagine James using an app where he can upload his financial data, use an integrated calculator to propose a child support figure, and leave comments on a shared document at 2 a.m. after he finishes his shift. This is the Uberization of divorce. It treats conflict as a series of data points to be optimized. The historical trend here is efficiency. The American user in 2026 values the ability to resolve their life without taking time off work or sitting in traffic. In Europe, the digital shift has focused more on the public access and structured guidance model. In the Netherlands, the Rechtwijzer platform became a world-renowned case study for digital justice. It was an online interface that guided couples through a series of questions designed to help them understand their legal position before they even spoke to a mediator. It wasn't just a spreadsheet, it was a pedagogical tool. It explained the why behind the law. Although the original Rechtwijzer model faced financial challenges, its DNA lives on in the 2026 European systems that use AI-driven chatbots to provide neutral, state-verified legal information to citizens for free. The step-by-step reality of a 2026 digital mediation in the US looks like this. Step 1: the algorithm. James and his spouse log into a portal that uses natural language processing to scan their initial statements for areas of agreement. The software highlights that they both want the children to stay in the same school district. This creates an immediate psychological win. Step 2: digital financial discovery. The app connects directly to their bank accounts and tax records via secure APIs, eliminating the months of paper chasing that historically plagued the American system. Step 3: guided negotiation. The AI flags inflammatory language in their chat logs, suggesting more neutral phrasing before the message is sent to the other party. In Europe, the digital step-by-step is often more integrated with the national ID system. In Estonia, for example, the entire divorce and mediation process can be handled through a digital signature. The historical trend in the EU has been toward the single digital gateway, where a citizen's legal, tax, and family status are managed in one secure environment. This reduces the risk of fraud that we discussed in previous parts. If the state already knows your income and your assets, the mediation becomes less about uncovering secrets and more about discussing the future. But what about the role of the human mediator in this digital age? In the US, the trend is toward the hybrid mediator, a professional who monitors the ODR platform and only steps in when the algorithm hits a stalemate. This has significantly lowered the cost for the average American family. If James only needs a human for 2 hours instead of 20, his bill drops from $8,000 to $800. This is the potential outcome of the democratization of mediation through tech. However, a major concern in 2026 is the digital divide. Historical data shows that while ODR is a boon for the tech-literate middle class, it can alienate those without high-speed internet or the cognitive load to navigate complex interfaces. In Europe, The response has been the creation of physical digital hubs, community centers where people can go to use the state's digital mediation tools with the help of a human facilitator. In the US, this is often left to the private sector or local libraries, creating a patchwork of accessibility that mirrors the fragmented nature of our legal system. One of the most fascinating case studies of 2026 is the use of virtual reality in mediation. Some high-end firms in New York and London are experimenting with VR environments where parties can meet in a simulated, calming space, like a virtual garden or a neutral beach, while being thousands of miles apart. The goal is to recapture the presence of in-person mediation without the logistical nightmare of travel. While this sounds like science fiction, the psychological data suggests that our brains process these VR interactions with a level of sincerity that a standard Zoom call lacks. As we look at the historical timeline, the shift to digital is the final nail in the coffin of the old adversarial courtroom model. In 1970, you had to stand before a judge in a suit. In 2026, you can resolve your entire estate from a laptop in a coffee shop. But this ease of access raises a haunting question. Does making divorce easier and cheaper actually lead to better outcomes for society, or does it devalue the social contract of marriage? Historical trends in countries with the most advanced digital mediation systems show that while the divorce rate doesn't necessarily spike, the post-divorce conflict rate drops. When the process is less painful, the aftermath is less bitter. But there is a group of people for whom this digital world is a prison. People who thrive on the drama of the courtroom and use the legal system as a weapon of harassment. In the American legal community, these are known as high-conflict personalities. In the next part, we are going to look at the dark arts of mediation. We will examine how narcissistic personalities try to game both the American and European systems. We will look at the specific tactics used to manipulate mediators, the psychological profiles that the 2026 systems are designed to catch, and what happens when the goal of a party isn't settlement, but total destruction. We will explore the specialized techniques like the new ways for families method that are being deployed to stop the legal system from becoming a tool for abuse. The high-tech, high-efficiency world of 2026 has a shadow, and we are about to step directly into it. The shadow world of mediation is populated by what psychologists and legal experts call high-conflict personalities, or HCPs. In the year 2026, the historical comparison between the US and Europe becomes a study in how two different legal philosophies attempt to restrain individuals who do not want peace, but rather total victory, and the continued emotional subjugation of their former partner. To understand this, let us look at a character named Robert in Phoenix, Arizona. Robert is a high-achieving executive with a history of controlling behavior. In the American adversarial tradition, a personality like Robert sees the mediation room not as a place for compromise, but as a new stage for the same power dynamics that existed in the marriage. The historical trend in the United States for handling these personalities has relied heavily on the skill of the individual mediator and the presence of protective legal counsel. In Robert's case, he might use a tactic known as gaslighting the process. Step 1 of this tactic involves overwhelming the mediator with a mountain of irrelevant data or accusations, designed to paint the other spouse as unstable or incompetent. Because American mediation is often private and market-driven, Robert might even attempt to shop for a mediator he perceives as more sympathetic to his status or gender, a phenomenon known as neutral bias seeking. Contrast this with the historical trend in Spain and France. In these jurisdictions, the state has moved toward a model of specialized domestic violence and high-conflict courts. If a case in Madrid shows signs of coercive control or extreme high-conflict dynamics, the system is designed to trigger an immediate shift from facilitative mediation to a more investigative and protective judicial track. While the US often attempts to mediate even the most difficult cases to save court time, the European trend in 2026 increasingly recognizes that mediation is a tool that requires two rational, good faith actors. If one actor is a narcissist using the process to continue an abusive cycle, the European model is more likely to provide a state-mandated buffer. A critical tool in the American arsenal for these cases is the New Ways for Families method, developed by Bill Eddy. This historical shift moved mediation away from talking about the past and toward a rigid, skill-based focus on the future. Step by step, the mediator forces the parties to use BIF communications: brief, informative, friendly, and firm. In 2026, Robert in Phoenix is not allowed to send long, rambling emails to his spouse. The mediator sets a boundary where all communication must happen through a monitored app like Our Family Wizard. If Robert violates this, the data is preserved for the court. This is the American answer to the dark arts, using technology to create a digital straitjacket for the high-conflict actor. In Europe, particularly in the UK, the approach to these dark arts has been influenced by the concept of parental alienation. While controversial and historically debated, the UK's CAFCAS, the Children and Family Court Advisory and Support Service, has developed specific frameworks to identify when a parent is using mediation as a weapon to turn a child against the other parent. Case studies from 2023 and 2024 show that European mediators are increasingly trained in forensic psychology to spot the subtle signs of alienation that a standard American mediator might miss in a rush to reach a financial settlement. Imagine if Robert tried to use his wealth to starve his spouse into a bad settlement during mediation. In the US, this is a common dark art known as financial attrition. Robert might drag out the discovery process, refusing to provide clear bank statements until the very last minute, hoping his spouse runs out of money for their attorney. In 2026, the potential outcomes for this behavior are becoming more severe. American judges are now more willing to sanction parties who use mediation as a stalling tactic, awarding attorney fees to the disadvantaged spouse. This is a historical shift from the 1990s, where mediation was a black box that the court rarely peeked into. The European response to financial attrition is often more systemic. In countries like Germany, the initial financial disclosures are so standardized and state-integrated that there is less room for Robert to hide the ball. The historical trend in Europe is toward transparency as a prerequisite for entry into the mediation process. If you are not transparent, you are not mediated. You are instead subjected to a rigorous state audit. This removes the incentive for the dark art of hiding assets, as the cost of the audit far outweighs the potential gain of the deception. We must also look at the psychological tactic of the victim-villain flip. This is where the high-conflict personality successfully convinces a mediator that they are actually the victim of the other spouse's aggression. In the US, where mediators are often focused on finding a middle ground, they can sometimes fall into the trap of false equivalence, assuming that because both people are arguing, both are equally responsible for the conflict. Historical data from the 2010s suggests that this was a major flaw in American mediation, leading to settlements that put victims of abuse at a further disadvantage. In 2026, however, the trend is toward trauma-informed mediation. Mediators are now trained to recognize the specific linguistic patterns of abusers versus victims. For example, a step-by-step analysis of a high-conflict session might reveal that the abuser uses globalizing language. "You always do this, everyone thinks you are crazy," while the victim uses specific, fear-based language. Modern American mediators now use a technique called looping to confirm understanding without validating the abuser's false narrative. This is a subtle but powerful evolution in the history of the practice. In the EU, the 2026 approach is further bolstered by the Istanbul Convention, which has influenced how mediation is conducted in cases with any history of violence. In many European countries, the moment a mediator identifies a significant power imbalance, they are legally required to stop the joint session and move to separate rooms or terminate the mediation entirely. This is the structural protection that many American activists are still fighting for on a state-by-state basis. What makes the dark arts so dangerous in 2026 is the intersection with AI. Imagine Robert using an AI tool to generate perfectly reasonable-sounding, but legally manipulative emails that mimic the Biff style, while still exerting control through subtle emotional triggers that only his spouse would recognize. This is the new frontier of digital abuse. American mediators are currently in a race to develop AI detection tools to ensure that the person they are mediating with is truly the person behind the screen, and not a machine-learned version of their best behavior. As we analyze these historical trends, it becomes clear that the US and Europe are both grappling with the same fundamental truth. Mediation is only as good as the honesty of the people at the table. While the US uses private professionals and specialized training to combat high-conflict personalities, Europe uses state-mandated structures and investigative frameworks. The potential outcomes of these two approaches determine whether a divorce ends in a clean break or a decades-long war of attrition. But there is one final piece of the puzzle that neither the US nor Europe has fully solved: the issue of cultural divergence. What happens when the two people at the table come from completely different worlds, where the very definition of family, honor, and property is in conflict? In the next part, we are going to explore the international divorce. We will look at the Hague Convention in practice, the nightmare of cross-border asset recovery, and why a divorce between a New Yorker and a Parisian can become a multi-year legal odyssey that spans 2 continents and 3 different legal systems. We will see how mediation behaves when it has to bridge the gap between 2 different versions of the truth. The international divorce is the ultimate stress test for the historical frameworks we have discussed. When a marriage crosses an ocean, the mediation table becomes a site of geopolitical negotiation. To understand the complexity of 2026, imagine a character named Sophia. Sophia is a graphic designer in Brooklyn who married a French architect, Marc, 10 years ago. They lived in Paris for 5 years before moving back to New York. Now they are separating. In a standard domestic case, the rules are clear. But for Sophia and Marc, the first step of mediation is not dividing assets. It is a battle over jurisdiction, known in legal circles as the race to the courthouse. The historical trend in international law has been dominated by the 1980 Hague Convention on the civil aspects of international child abduction. While this treaty was originally designed to prevent one parent from fleeing with a child, in the context of mediation, it serves as a massive, invisible shadow over every conversation. If Sophia and Marc cannot agree on where the children will live, the mediation must navigate the terrifying reality that one parent might be legally barred from taking the child to their home country. Case studies from the last decade show that international mediations often fail because the parties are terrified that by compromising, they are inadvertently waiving their rights under the Hague Convention. In the United States, the historical approach to cross-border mediation has been largely ad hoc. Sophia would likely hire a private international mediator in Manhattan, costing upwards of $600 an hour, who must have a working knowledge of both New York's equitable distribution laws and the French regime of community of property. This is where the step-by-step detail becomes a nightmare of forensic accounting. Step 1. Characterizing the assets. Is the apartment in the Marais district of Paris marital property, or separate property under French law? Step 2. Valuation and tax. If they sell the Paris apartment to buy out Sophia's share of the Brooklyn brownstone, they are hit with French capital gains taxes and US IRS reporting requirements. An American mediator in 2026 must act as a diplomat, a tax strategist, and a legal historian all at once. Across the Atlantic, the European Union attempted to solve this chaos through the 2008 EU Mediation Directive and the subsequent Brussels II-tier regulation. These were landmark historical shifts intended to create a predictable legal space. For Marc, if he had filed in France first, the jus lis pendens rule would usually mean the French court has priority. However, mediation is the preferred escape hatch. The historical trend in Europe has been to use specialized international family mediators who are trained specifically in the cross-border conflicts of the EU. The data from the European Judicial Network shows that mediated settlements are significantly more likely to be recognized and enforced across borders than court orders, which can be tied up in local appeals for years. Imagine if Sophia and Marc's mediation takes place via Zoom, with Sophia in New York and Marc in Paris. The mediator has to manage not just the time difference, but the cultural divergence in what constitutes a fair outcome. In the US, there is a historical emphasis on financial independence post-divorce. The potential outcome often involves a clean break where assets are split and spousal support is limited. In many European cultures, there is a stronger historical emphasis on maintaining the standard of living for the lower-earning spouse, sometimes indefinitely. This is the clash of the clean break versus the ongoing obligation. The step-by-step reality of a cross-border mediation in 2026 involves a high degree of technical synchronization. Step 1. Choosing the governing law. The parties must sign a choice of law agreement. Will they follow New York law or French law? This single decision can result in a swing of hundreds of thousands of dollars in asset division. Step 2. The mirror order. Once an agreement is reached in mediation, it cannot just be signed and filed. To be safe, it must be turned into a court order in both jurisdictions. This is the mirror. If Marc stops paying child support while in France, Sophia needs a French court to recognize the American agreement immediately. Data from the International Academy of Family Lawyers indicates that the average cost of a contested international divorce in 2026 can exceed $250,000. Mediation is the only viable path for the middle class to avoid total financial ruin in these scenarios. Yet, the historical trend shows that mediation is often underutilized in international cases because of a lack of trust in foreign legal systems. Sophia might fear that a French mediator will favor Marc's cultural perspective, while Marc might feel that the New York system is overly litigious and biased toward the primary caregiver. Case studies in 2026 are increasingly highlighting the role of the cross-border co-mediator. This is a new historical evolution where two mediators, one from the US and one from Europe, work together in a single session. They act as cultural and legal translators. When the American mediator suggests a 50-50 custody split, the European mediator can explain the local school schedules and holiday traditions that might make a traditional American week-on week-off schedule impossible. This dual-neutral model is the gold standard for 2026, though it doubles the hourly rate. Another massive hurdle is the recovery of hidden international assets. The historical trend of using offshore accounts or Swiss banks as a shield during divorce is being dismantled by the Common Reporting Standard, CRS, and the U.S. Foreign Account Tax Compliance Act, FATCA. In Sophia and Mark's mediation, the mediator now has access to a much higher degree of global financial transparency than they did even 5 years ago. Step by step, the mediator can walk through the global disclosure forms, knowing that any lie told in mediation could result in criminal penalties for tax evasion in multiple countries. This has shifted mediation from a game of hide-and-seek to a game of risk management. But what happens when the conflict isn't just about money or geography, but about the fundamental values of the two societies? In the US, we have a historical focus on individual liberty and the right to reinvent oneself. In many European societies, there is a deeper historical focus on social stability and the preservation of the family's heritage. This tension is never more apparent than when discussing a child's religious or cultural upbringing in two different countries. As we look at the potential outcomes of these international sagas, we see a world that is becoming more integrated yet more complex. The history of mediation is being rewritten by families like Sophia and Mark's, who are forcing the legal systems of two continents to talk to each other. But there is a final, even more radical shift occurring. As the costs and complexities of international law become unbearable, some are looking toward a completely different solution: the complete removal of the state from the marital contract. In the next part, we will explore the rise of the private contract and the delegalization of divorce. We will examine the historical trend of the prenuptial agreement in the US versus the marriage contract in Europe, and why 2026 might be the year that people stop asking the government for permission to end their relationships altogether. We are entering the world of the autonomous family, where mediation is not a step toward a court order, but the final word in a private agreement that the state may never even see. This is the ultimate evolution of the no-fault revolution, and it carries risks that could redefine the very concept of social justice. The delegalization of divorce through private contracts represents the final frontier in the historical evolution of mediation. To understand how we reached this point in 2026, we have to look at the shifting philosophy of the marital contract itself. In the mid-20th century, marriage was a tripartite agreement between two individuals and the state. Today, we are witnessing a historical trend where the state is being unceremoniously evicted from the room. Imagine a character named Ethan in Boston. Ethan is a tech entrepreneur getting married for the second time. For Ethan, the mediation process did not begin at the point of separation. It began 2 years before the wedding with the drafting of a comprehensive, mediation-integrated prenuptial agreement. This is the rise of the sunset clause and the prepackaged divorce. In the United States, the historical trend has moved from viewing prenups as pessimistic to viewing them as essential financial planning. But the 2026 version is different. Step 1 in Ethan's process is the mandatory mediation provision. This clause stipulates that if the marriage fails, the parties are contractually forbidden from filing a court petition until they have completed at least 40 hours of private mediation. By signing this, Ethan has effectively signed away his immediate right to a day in court in exchange for a private, autonomous resolution. This is the privatization of justice. In Europe, this trend takes the form of the marriage contract, which has a much deeper historical pedigree, particularly in civil law jurisdictions like Germany and the Netherlands. While an American prenup often focuses on protecting assets, the European marriage contract often serves as a roadmap for the entire life of the union.
Imagine Ethan's counterpart in Amsterdam, Lars.
Lars and his partner choose a specific matrimonial regime at the time of marriage, either communal property or separate property. In 2026, the potential outcomes for Lars are governed by a document that was mediated and notarized a decade ago. If they divorce, the mediation is simply an audit of that original contract. There is no discovery, no subpoenas, and no legal war. The mediator is merely an accountant of the heart. The data shows a massive surge in these private agreements. In 2010, only about 3% of marrying couples in the US had a prenup. By 2026, That number has climbed to nearly 20% among millennials and Gen Z. The step-by-step detail of why this is happening is tied to the fear of the legal system. Case studies from the early 2020s showed that couples who mediated their own rules before things went wrong were 60% more likely to remain amicable after a split. For Ethan in Boston, the mediation table in 2026 is a place where he reviews a contract he helped build, rather than a place where a judge imposes a set of state laws he never voted for. However, this shift toward total autonomy brings us to the risk of the shadow divorce. This is a phenomenon where the entire dissolution happens behind closed doors, with no public record and no judicial oversight. In the US, this is achieved through private binding arbitration. Step 1. The parties mediate. Step 2. Any unresolved issues are sent to a private arbitrator, often a retired judge, whose decision is final and non-appealable. Step 3. The results are filed under seal. The historical trend here is the creation of a tiered justice system. The wealthy, like Ethan, can afford to buy a private, quiet exit, while the rest of society is left to the slow, public gears of the state court. In Europe, the delegalization is more institutionalized. We previously discussed the French model where a notary, not a judge, finalizes the divorce. But in 2026, we are seeing the emergence of the collaborative law movement taking over the mediation space. This is a step-by-step process where both parties and their lawyers sign a disqualification agreement. If the mediation fails and they go to court, the lawyers are fired and cannot represent them in the litigation. This creates a powerful financial and psychological incentive to stay at the mediation table. The historical trend in the UK and Scandinavia suggests that this collaborative approach is slowly replacing the traditional mediator model because it combines the protection of an attorney with the peace-seeking goals of mediation. But there is a major social justice concern with this movement toward the private contract: the erosion of public standards. If every divorce is a private contract mediated in a vacuum, how does society ensure that people are being treated fairly? In the US, the historical trend of alimony or spousal support was designed to protect the stay-at-home parent. If Ethan's private contract waives alimony entirely, and a mediator helps him enforce that, the state may never have the chance to intervene and prevent his spouse from falling into poverty. This is the dark side of the no-fault, no-judge revolution. Let's look at a case study from 2025 involving a high-asset divorce in California. The couple had a private mediation agreement that used a unique formula for child support that was significantly lower than the state guideline. Because they resolved it privately and only filed the final decree for a rubber-stamped signature, the court never saw the underlying math. The potential outcome in this scenario is a privatization of child welfare that undermines the state's historical role as the ultimate protector of the child's interests. In Europe, the response to this risk has been the mandatory fairness review. Even in the most autonomous systems like the Dutch or the French, a notary or a social official has a historical and legal duty to flag any agreement that appears grossly unconscionable. This is the step-by-step check and balance that the US system often lacks in its push for total contractual freedom. Why is the US so resistant to these fairness reviews? It goes back to the historical American distrust of the state. We would rather have the freedom to make a bad deal than have a government official tell us what a good deal looks like. This cultural DNA makes American mediation a high-risk, high-reward environment. For Ethan, it means he has total control over his future. For someone with less leverage, it means they might be mediated into a corner with no way out. The historical timeline is clear. We moved from the era of proof of fault to the era of no fault, and we are now entering the era of no court. Mediation has gone from being an alternative to being the default, and now it is becoming the law itself. By 2026, the traditional courtroom is becoming a museum. The real decisions are happening in quiet offices, over encrypted video calls, and within the clauses of contracts signed years in advance. But as we dismantle the old legal structures, we have to ask what replaces them. If the law of the land is replaced by the law of the contract, what happens to the concept of precedent? What happens when there are no more public rulings to guide future generations on what is fair and just? We are trading the predictability of the state for the flexibility of the individual, but the cost of that flexibility might be the loss of a shared moral compass. In the final part of this masterclass, we are going to bring it all together. We will look at the global synthesis of 2026. We will project the next decade of family law, the role of AI-led legislative reform, and the ultimate question: after 50 years of comparison, which system actually produces the happiest families? We will reveal the data on long-term life satisfaction, the impact on the children of the mediation revolution, and the one thing that both the US and Europe still haven't figured out. The conclusion to this deep dive will give you the definitive map for the future of human separation. The definitive map for the future of human separation is being drawn right now, and as we reach the year 2026, the data from 5 decades of experimentation has finally started to speak. To synthesize the global reality, we have to look at the ultimate metric: long-term life satisfaction and the stability of the children involved. In the United States, we have historically measured success by the absence of a trial. In Europe, success is increasingly measured by the presence of a functional co-parenting relationship 10 years later. Imagine a character named Jordan in Philadelphia. Jordan represents the culmination of the American mediation journey. After a mediated divorce in 2026, Jordan does not have the lingering debt of a 6-figure legal battle, but he does have a complex, 30-page private agreement that requires constant digital management. Step 1 in this final synthesis is the realization that both systems are converging toward a managed autonomy model. The historical trend shows that the US is moving away from the pure Wild West of private mediation and toward a more regulated, accredited professional standard. Conversely, Europe is moving away from the rigid, slow-moving state bureaucracy and toward the fast-paced digital efficiency of American ODR. This is the great synthesis of 2026. The potential outcomes of this convergence suggest a future where the location of your divorce matters less than the technology you use to resolve it. Let us look at the data on the children of the mediation revolution. A 2025 longitudinal study spanning 12 countries found that children whose parents used mediation, regardless of whether it was the American private model or the European state model, showed significantly lower levels of cortisol and higher academic performance compared to those whose parents litigated. The specific step-by-step detail that made the difference was not the financial split, but the communication protocol. In the US, this is often handled by a private parenting coordinator. In Europe, it is handled by a state social worker. The result is the same: the removal of the child from the center of the conflict. However, the one thing that both the US and Europe still have not figured out is the concept of the non-standard family. Historical trends in both regions were built on the foundation of the nuclear, heterosexual, two-parent household. As we sit in 2026, the mediation systems are struggling to handle the complexities of polyamorous separations, multi-generational households, and the growing trend of platonic co-parenting where there was never a romantic marriage to begin with. Case studies from California and the Netherlands show that mediators are currently flying blind in these scenarios, as the historical legal statutes provide no roadmap for dividing a 3-person estate or determining the rights of a non-biological co-parenting partner. Imagine Jordan in a scenario where his family structure does not fit the checkboxes on the standard mediation intake form. This is where the human element still triumphs over the algorithm. In the US, this has led to the rise of the niche mediator, specialists who focus exclusively on LGBTQ+ families or complex multi-generational wealth. In Europe, it has led to a push for legislative reform to redefine the legal definition of family in the civil code. The potential outcomes for these non-traditional families depend entirely on whether the mediation system can adapt fast enough to the changing social reality. The final data point we must consider is the cost-benefit ratio of the two systems over a lifetime. In the US, the historical trend of high-cost, high-protection mediation leads to a higher rate of finality. Once an American mediation is done, it is usually done forever because the agreement is so legally dense. In Europe, the low-cost, state-subsidized model leads to a higher rate of return to the system. Because it is easier and cheaper to access the state mediator, European families are more likely to return to mediation every time a new conflict arises, for example, when a child changes schools or a parent moves cities. This is the trade-off: a single, expensive, permanent American settlement versus a series of cheap, ongoing European adjustments. Let us look at the step-by-step reality of the future of human separation in 2027 and beyond. Step 1: Automated triage. An AI will analyze the degree of conflict, the complexity of assets, and the psychological state of the parties to recommend either a fast-track digital path or a high-touch, human-led path. Step 2: Decentralized discovery. Blockchain technology will be used to create an immutable, transparent record of marital assets, making it impossible to hide money or manipulate financial data. Step 3: The living agreement. Instead of a static PDF, the mediation agreement will be a dynamic digital contract that automatically adjusts child support based on real-time inflation and updates the parenting schedule based on the kids' school calendars. The historical comparison reveals that while the US and Europe started at opposite ends of the spectrum, one favoring the market and the individual, the other favoring the state and the collective, they have both arrived at the same conclusion. Conflict is too expensive for society to leave to the lawyers. The shift from a legal battle to a mediated conversation is the single most important change in domestic law in the last 500 years. It represents a move from the rule of force to the rule of consensus. Jordan in Philadelphia and Lars in Amsterdam are ultimately searching for the same thing: a way to end a chapter of their lives without destroying their future. The definitive map for the future of human separation shows that the most successful people are those who view mediation not as a legal requirement, but as a skill-building exercise. The history of mediation is not a history of laws. It is a history of the evolution of human communication. We have moved from proving who was the villain to agreeing on how to be neighbors. As we close this 10-part masterclass, we have covered the legal milestones, the financial mechanics, the battle for the children, the digital frontier, and the dark arts of the high-conflict personality. We have seen how the US and Europe have learned from each other, stolen each other's ideas, and ultimately created a global framework for peace. But even with all this history and data, the most important factor remains the individual choice. You can have the best AI mediator in the world and the most supportive state structure, but if the two people at the table are not willing to put down their weapons, the system will fail. The future of mediation is not just about smarter contracts or faster algorithms. It is about a fundamental shift in how we view the end of a relationship. It is the move from seeing divorce as a failure to seeing it as a transition. And in that transition, the history of the US and Europe gives us the tools to ensure that the next generation does not have to fight the same wars their parents did. But there is a final looming shadow that we have only touched upon. As we look toward 2030, a new question is emerging. If we can automate the end of a marriage, can we also automate the beginning? If mediation can solve our conflicts, can it also prevent them before the first date? The intersection of behavioral psychology, big data, and family law is creating a world where the very concept of a spontaneous relationship is under threat. In our next series, we will dive into the brave new world of algorithmic relationships and the upcoming laws that may regulate who you are allowed to marry based on your compatibility data. The era of the premediated life is almost here.